Corporation. A corporation is a business entity separate from its shareholders. Therefore, shareholders of a corporation are not personally liable for the corporation's obligations unless the corporation was not properly formed or the shareholders abused its corporate form. A corporation requires proper formalities for creation, which include filing with the Secretary of State. A closely held corporation is one in which there are few shareholders, and liability of the shareholders is more readily found because of its more intimate nature. Corporate veil. A shareholder is generally not personally liable unless the corporate form is abused. A court will disregard the separateness of a corporation and its shareholders and pierce the veil if it appears that 1. The corporation was undercapitalized at its inception, 2. The corporate formalities were not adhered to, or 3. The corporation was created to perpetrate a fraud. It will also consider whether a parent corporation was operating by mixing its directors and officers with another corporation owned by it. Derivative actions. A shareholder may bring a derivative action on behalf of the other shareholders of the corporation for a breach by the directors. Any recovery will go to the corporation rather than to the shareholder personally. To bring such an action, the shareholder must 1. Have made a demand on the board for the complaint of action, to which the board either refused or 90 days have passed without an answer, or demand would be futile. 2. The shareholder must adequately represent the other shareholders, and 3. The shareholder must hold shares throughout the entire suit. Breach of duty of loyalty. A director has the duty to put the corporation's best interest before his own. The duty of loyalty can be breached in 3 ways. 1. Usurping a corporate opportunity. 2. Engaging in an interested director transaction. And 3. Engaging in a competing venture. Interested director. Transaction. A director is not permitted to engage as an interested party in a transaction, which essentially means that he may not sit on both sides of the transaction, or that the director may not engage in a transaction with one of his family members, unless he gets the approval of the majority of the disinterested board, or its shareholders, or the transaction is substantively fair. Duty of care. A director owed the corporation a duty of care to act in good faith, as a reasonable prudent director would under the circumstances. Business judgment rule. The business judgment rule protects the good faith decisions made by directors in compliance with the duty of care that in hindsight end up being erroneous. Duty to shareholders. Generally, shareholders do not owe a duty to other shareholders. However, a majority shareholder owes the duty to a minority shareholder not to use its majority share to discriminate against the minority shareholder, and not to sell his shares to a prospective looter. Liability of corporation at dissolution. A corporation that ceases business is still held liable for debts to creditors. A shareholder who contributes capital will receive reimbursement. Equitable subordination. Under equitable subordination, all creditors, whether shareholder creditors or outsiders, may seek to collect their debt to the corporation equally. However, if a shareholder acted wrongfully, the Deep Rock Doctrine prevents him from recovering equally. De jure corporation. A de jure corporation is one that is properly formed. To form a de jure corporation, the parties have to prepare the necessary documents required by the state for incorporation. De facto corporation. A de facto corporation is where the parties take all the necessary steps to incorporate, but for some reason their attempt to incorporate was unsuccessful. If the parties have a good faith belief that a corporation was formed, a court can find that a de facto corporation was created, which gives the parties all the same benefits and obligations that would arise under a normally created corporation. Liability of a corporation for damages caused by its agents. A corporation can be liable for damages caused by its agents during the scope of their employment. In a corporation, directors and officers are considered agents of the corporation. If the damages were created completely outside of the scope of their employment, then a corporation will not be found to be liable for the damages. The fact that Lenny was working in furtherance of the business interests of the corporation does not mean that he could not be held liable separately. General partnership. A general partnership arises when two people agree to enter into a business venture for profit. Under a general partnership, the partners are not protected from liability, like a shareholder of a corporation is. Therefore, if a general partnership is formed and a party brings a suit against one partner for damages arising out of their work for the partnership, then all partners are personally liable for any award against the partnership. Breach of contract. If Tesco is to be found liable to Examco, it will be on a breach of contract theory. Breach of contract occurs where there is a valid contract, a breach, and then damages as a result of the breach. A valid contract exists when there is an offer, acceptance, consideration, and no defenses to contract formation. Agency. Agency is where a principal with capacity manifests assent that an agent act on behalf of the principal for its benefit, and subject to its control, followed by the agent manifesting assent to do the same. Authority. A principal is liable on the contracts entered into by their agent on their behalf so long as the agent has authority. Authority can come in three forms: actual authority, apparent authority, and ratification. Actual authority. Actual authority is the authority that the agent reasonably believes that they have based upon the manifestations of the principal. Actual authority can be express or implied. Express actual authority. Express actual authority is the authority given from the four corners of the agency agreement. Usually in the corporate setting, when a contract such as this is entered into, the board of directors will usually vote to pass a resolution to give the president of the company the authority to enter into the contract. However, there was no such board resolution here since Amy did not consult with Ben prior to signing the contract. Since there are no facts going to express authority, a different form of authority must be found to bind Tesco to the contract with Examco. Implied actual authority. Implied actual authority is the authority that the agent reasonably believes that they have based upon necessity in order to carry out their express authority, customs of the position held by the agent, and by prior dealings with the principal. Here Amy, as president of Tesco, would likely have implied actual authority to enter into the Examco contract by virtue of her position as president of the company. Presidents of corporations customarily have the authority to enter into binding contracts with other companies. Tesco will argue that, although Amy was president and had authority to enter into smaller contracts, this contract was different in the fact that it went 10 years into the future, and that Amy was giving such a huge discount. Tesco will argue that this sort of contract required express board resolution, and thus Amy could not have reasonably believed to have authority to enter into it. However, the facts state that Amy gave the standard 50% discount, thus it seems like this was a regular occurrence of the corporation to enter into contracts of this nature. As such, there was implied actual authority. Apparent authority. Apparent authority is the authority that a third party reasonably believes that the agent possesses based upon the manifestations of the principal. One form of manifestation by the principal would be the position that the principal has placed the agent in is a position that is usually associate, with the grant of authority. Ratification. Ratification occurs where after the agent has entered into a contract, the principal has knowledge of it and accepts its benefits. Liability of shareholders. Shareholders of a corporation are only personally liable for the cost of their shares of stock in the corporation. They are not personally liable for the corporation's debts, liabilities, or obligations unless the corporate veil can be pierced. Piercing the corporate veil. The corporate veil is pierced based upon a variety of factors. These factors include whether there was fraudulent conduct by the shareholders, whether the corporation is undercapitalized, whether the corporation is simply an alter ego of the shareholders, and whether the creditor of the corporation is an involuntary creditor. Fraud. Fraud is the misrepresentation of a material fact known to be false with the intent to induce some action upon another where the other suffers damages. Alter ego. A corporation acting as the alter ego of the shareholders will be found where the shareholders forego the usual formalities of corporate status. Undercapitalization. Undercapitalization of a corporation occurs where the corporation does not keep enough surplus cash on hand in order to pay the foreseeable liabilities of the corporation. Shareholders' liability. Usually a shareholder of the company will be held liable as a result of veil piercing. However, the shareholder who does not have control of the corporation may likely bring a claim against the directors/officers for breach of fiduciary duty that resulted in a third party piercing the corporate veil. The board. In a corporation, the board of directors run the big picture of the corporation. They appoint the officers and managers as well as vote on major corporate transactions. Board of directors can be comprised of two types of directors: inside directors and outside directors. Outside directors are those who are otherwise disinterested in the day-to-day operations, because their only relationship to the corporation is their board position. Inside directors, however, are directors that work in the corporation as managers. Power of the board meeting. The board of directors votes on major corporate transactions. These include mergers, acquisitions, partial or whole asset sales, dividend distributions, and new large investments. The board of directors, unless specified otherwise in the bylaws, must approve all the matters before it by a majority vote. Inside directors and outside directors' votes are equal. In order to have a proper vote, there must be quorum. Quorum requires a majority of disinterested directors. Disinterested directors are those directors that do not have a personal stake in the matter at hand. Right to inspect records. Shareholder inspection rights are a keystone right of shareholders. Shareholders, if certain conditions are met, have the right to inspect the books and records of the corporation, including board meeting minutes. In order for a shareholder to have inspection rights, they must show that they are indeed a shareholder and that they have a proper purpose in asking for inspection. Proper purpose. A shareholder must have a proper purpose. A proper purpose can be many things, including investigating potential fraud, reviewing financial statements, making sure corporate formalities were followed properly. A proper purpose is anything that has to do with a shareholder's interests in the health of the corporation, as it relates to their ownership of the corporation. An improper purpose arises when a shareholder is attempting to inspect the records for personal benefit, or with the goals to harm the corporation. Direct suit. In a direct suit, Evan is suing the board of directors himself as a shareholder. A direct suit involves a board infringing on the rights of individual shareholders. Derivative suit. A derivative suit is a lawsuit where a shareholder demands that the corporation sue the board of directors directly for some violation. Usually a fiduciary duty violation. Evan will have to make a demand on the board or show that demand is futile. Duty of care. The duty of care requires a director to act as a reasonably prudent director under the circumstances. The duty of care requires that a director act with the requisite skill, knowledge, and care of an ordinary director, and employ their personal skills in their care. As part of the duty of care, directors must make sure that they are properly informed in regard to the corporate decisions that they make. Business Judgment Rule. The Business Judgment Rule, BJR, is a presumption that directors acted in an informed manner in the best interests of the corporation. The BJR presumes that directors acted in good faith and protects them from liability for basic corporate decisions. For a shareholder to succeed in arguing the duty of care violation, they must rebut the BJR. The BJR can be rebutted through a showing of bad faith, self-dealing, gross negligence towards their duties, and more. H. Duty of loyalty. Under the duty of loyalty, a director has to act in the best interests of the corporation. Self-dealing. A director may not enter into the transaction that the director has a conflict of interest with. A conflicted transaction may nonetheless be valid if the conflict is disclosed and either 1, a majority of disinterested shareholders approve, 2, majority of disinterested directors approve, or if the transaction is fair.